Can I just say something about Andrea?
Like many of you, I'm sure, I woke up Saturday morning to news that the U.S. military had gone into Venezuela and captured Nicolas Maduro, the president, not president, which we'll have to get into, and his wife, the First Lady Celia Flores. And we're in the process of transporting them to the United States for criminal prosecution. The indictment against them out of the Southern District of New York was unsealed. So I went and took a look. And general summary is it charges them with conspiracy to engage in narcoterrorism. There's other people named in the indictment. They're Maduro's son. One of the, I think, generals, the guy who runs the Venezuela Armed Forces, some other folks as well, and just essentially alleges a pattern of conspiring to traffic drugs through Venezuela with a number of different cartels: the Sinaloa cartel, the FARC out of Colombia, Tren de Aragua, which is out of Venezuela itself. And so basically through these various relationships, we're conspiring to import cocaine into the United States and essentially for their own personal benefit. And, I'm a lawyer. I'm a criminal defense lawyer. And I am a little maybe extra attuned to the complications of international criminal prosecution. And so the whole manner in which this came about definitely caught my attention because I can't help but notice, this is not a formal extradition process. We had a warrant for him, but warrants typically only have power within the territorial jurisdiction of the sovereign that issued them. So when the sovereign is the state, it's within your own state. If you want to serve it out of state, you typically got to get permission from that other state. And the same thing happens at the international level. And so the process to do that, to get permission, is the extradition process. Now, there's obviously practical reasons why that wasn't going to happen in this case. Maduro, legitimate or not, is sitting at the head of government of Venezuela. Venezuela has in their constitution a asylum clause. It basically specifically says Venezuelans will not be extradited. And their process also goes through not just a judicial review, but also an executive review. So at the end of the day, he gets to decide whether he is going to be extradited to the United States or not. Gee, I wonder what he's gonna decide about that. So it's not real surprising that they didn't go through that process. But it did naturally make me wonder, is this going to be an issue? Is this going to cause problems? And so I took a look at some of the law, of course, and that's what I'm going to be sharing with you today. Now, this is obviously a politically, quite hot topic. Feelings on all sides about it, and, I think legitimately so. I'm not going to, of course, be taking a political position on this, but we're going to see as we go through some of the case law how these issues do kind of come up and how they're going to be fleshed out. So I started by remembering way, way back, yes, in my own lifetime, I'm old enough to have a memory of when Noriega was captured down there in Panama. And I mean, I like am old enough to remember specifically, like when it was on the news, how they were blasting heavy metal, at the church where he was holed up to try to run him out and stuff. But I never really followed it beyond that. I think I was like 12 years old when that happened or something. So it's part of my memory, but not something that I was like real culturally engaged with at the time. But it definitely seemed like the most on point, factually, kind of precedent that we have for an action like this, a situation where the U.S. uses its military to go into a foreign country to seize somebody from the foreign country's government and bring them to the US for prosecution. So I went and looked at the Noriega case. We're going to look at the memorandum decision that came out of the Southern District of Florida. So this is the lower court decision. It's quite extensive. What happened is, I'll just give you the kind of broad overview first. He raised a series of challenges to his arrest, his capture, his prosecution. Those were all denied. That's going to be the outcome of this decision. He then went to trial, was convicted, and appealed up to the 11th Circuit. The 11th Circuit affirmed these decisions that the Florida District Court had made. So Noriega went to prison, and he was ultimately, they transported him, I think, to France. They extradited him to France. He spent some time in prison there, and then ultimately was sent back to Panama, where he was also imprisoned. And he died in prison. I don't remember exactly when, but he is no longer with us at this point. He is no longer going to live any of his life as a free man. So this is a very long decision. I'm not going to read probably every single word of it, but I do want to go in some detail through the facts and a lot of the legal arguments so that we can see how these line up and how they don't with what decisions were made vis-a-vis Maduro. So this is an omnibus order, just meaning several motions were filed in the context of like one filing, one hearing. So it's an order that addresses multiple legal rulings. Comes before the court on the several motions of defendants General Manuel Antonio Noriega and Lieutenant Colonel Luis del Cid to dismiss for lack of jurisdiction the indictment which charges them with various narcotics-related offenses. So right off the bat, some comparisons. We've got foreign leaders. In this case, they are military leaders. And narcotics-related offenses. That's what they were indicted for, and kind of a similar, frankly, type of scenario that we'll get into. The case at bar presents the court with a drama of international proportions, considering the status of the principal defendant and the difficult circumstances under which he was brought before this court. The pertinent facts are as follows. On February 14th, 1988, a federal grand jury sitting in Miami, Florida, returned a 12-count indictment charging General Manuel Antonio Noriega with participating in an international conspiracy to import cocaine and materials used in producing cocaine into and out of the United States. Pretty much the same kind of crime that's being alleged against the Maduros. Conspiring to move cocaine into the United States. He is alleged to have exploited his official position as head of the intelligence branch of the Panamanian National Guard and then as commander-in-chief of the Panamanian Defense Forces to receive payoffs in return for assisting and protecting international drug traffickers, including various members of the Medellin cartel, in conducting narcotics and money laundering operations in Panama. Still more overlap. It's Sinaloa in the case of Maduro, and it's also FARC is also involved. So Colombian and Mexican cartels, Medellin just being a different Mexican cartel. Same type of idea. They've got power and influence in government. They are using that power and influence to be able to empower these narcotics traffickers and benefit from that personally. Specifically, the indictment charges that General Noriega protected cocaine shipments from Colombia through Panama to the United States, almost identical as what we're dealing with Venezuela. Arranged for the transshipment and sale to the Medellin cartel of ether and acetone, including such chemicals previously seized by the Panamanian Defense Forces, provided refuge and a base for continued operations for the members of the Medellin cartel after the Colombian government's crackdown on drug traffickers following the murder of Colombian Minister of Justice Rodrigo Lara Bonilla. Agreed to protect a cocaine laboratory in Darien Province, Panama. Darien. Just that's those of you that know the Darien Gap. Yeah, this is where we're talking about. And assured the safe passage of millions of dollars of narcotic proceeds from the United States into Panamanian banks. He traveled to Cuba. He met with Castro. Another Cuban link. We have that with Maduro as well. Who, according to the indictment, mediated a dispute between Noriega and the cartel caused by the Panamanian troops' seizure of a drug laboratory that Noriega was paid to protect. All of these activities were allegedly undertaken for General Noriega's own personal profit. Same thing as we have with Maduro's. It's not an argument that this is like an official state policy or that this is, going into the treasury for the benefit of the people or anything like that. This is personal enrichment. Then there's the guy who is his personal secretary who helped him with that. So they're charged with a pattern of racketeering activity in violation of RICO, conspiracy to distribute and import cocaine into the United States, distributing and abetting, aiding and abetting the distribution of cocaine, intending that it be imported into the United States. And so just a variety of these different charges. Procedurally, they granted him a motion to allow special appearance of counsel, despite the fact that Noriega was a fugitive and not before the court at that time. So before he was ever taken from Panama, they allowed an attorney to come in, move on his behalf to dismiss the indictment on the ground that the United States laws could not be applied to a foreign leader whose alleged illegal activities all occurred outside the territorial bounds of the United States. Counsel further argued that Noriega was immune from prosecution as head of state and diplomat, and that his alleged narcotics offenses constituted acts of state not properly reviewable by this court. So now we're going to start getting into some of the complications that come up when you deal with these political figures, international figures, prosecuting them in the United States. You run into a potential big conflict between the diplomatic choices of the executive, between the the international law that's at play that governs the relations between the countries, and what's the court's role in all of this. The court's not a political body, not supposed to be anyway. They're not supposed to be engaging in things like determining foreign policy. So how much do they defer to the executive? How much do they defer to international law? How much do they just decide for themselves? It gets real tricky real fast. And a lot of these issues we're going to run into, no question about it, with the Maduro prosecution. There's going to be similar types of challenges raised and similar types of implications. So the court denied the motion for the reasons set forth below. At the time, the court noted that this case was fraught with political overtones, but it was nonetheless unlikely that General Noriega would ever be brought to the United States to answer the charges against him. The former observation proved to be considerably more correct than the latter in light of subsequent events. In the interval between the time the indictment was issued and the defendants were arrested, relations between the U.S. and General Noriega deteriorated considerably. Shortly after charges against Noriega were brought, the general delivered a widely publicized speech in which he brought a machete crashing down on a podium while denouncing the United States. He is a very dramatic. A lot of these dictatorial types of leaders, very dramatic. Didn't we see something similar with Maduro, where he's calling him out, come get me, crashing down the machete onto the podium? Noriega declared that a state of war existed between Panama and the United States. Tensions between the two countries further increased the next day when U.S. military forces in Panama were put on alert after Panamanian troops shot and killed an American soldier, wounded another, and beat a Navy couple. We got a little bit of a difference here, which is that the military was already present in Panama. We have interests in Panama through the Panama Canal. And so not a situation like we're dealing with in Venezuela, where there's no base, no U.S. presence before this incident. They had to go in deliberately for the purpose of taking Maduro. So we do have a little bit of a factual distinction here. 3 days later, on December 20th, President Bush ordered U.S. troops into combat in Panama City on a mission whose stated goals were to safeguard American lives, restore democracy, preserve the Panama Canal treaties, and seize General Noriega to face federal drug charges in the United States. This is definitely one of the issues that's come up, you know, in the discourse after Maduro was seized. The fact that this was a unilateral presidential act didn't come from Congress, and that's going to be far beyond the scope of this video. You know, whole war powers and foreign power and the separation of powers and who gets to do what as far as the president and the executive. And the bottom line is just it really isn't that crystal clear, and the court's real unlikely to get involved in those types of decisions because it's getting into political questions. It's getting into issues where just it's better for the court to defer to them to kind of sort it out for themselves. So, not going to take a real strong opinion on that, but I'm just going to note that that is what happened here. President Bush ordered U.S. troops into combat, like specifically sent them on a combat mission, did that unilaterally, and part of that goal was to seize Noriega to face the drug charges. Before U.S. troops were engaged, American officials arranged a ceremony in which Guillermo Endara was sworn in as president and recognized by the United States as the legitimate head of the government of Panama. Endara was reported to have won the Panamanian presidential election held several months earlier, the results of which were nullified and disregarded by General Noriega. Just continue to have these factual overlaps. It's almost like, you know, the more things change, the more they stay the same. There's like no real new story, you know, just kind of retellings of the same stories. Pretty equivalent to the situation we're dealing with in Venezuela, as far back as 2018, 2019. Not real clear that Maduro had any democratic right to remain in office, but nevertheless didn't leave. You know, that was repeated then in 2024 elections. And so this case, they swore in the you know, the winner of the opposition basically before they left. In Venezuela, they've sworn in the vice president, who I'm not sure how, if Maduro, you know, isn't legitimate, how the vice president is legitimate, but these are political questions way far beyond the purview of the legal stuff we're here to talk about. Not long after the invasion commenced, Defendant Del Cid, the commander of the troops, he surrendered. He was transferred into custody of the US DEA, who thereupon arrested him for the offenses for which he is under indictment in this court. The apprehension of General Noriega was not quite so easy. He successfully eluded American forces for several days, prompting the US government to offer a $1 million bounty for his capture. There was a bounty out for Maduro, forget what exactly it was, but similar type of situation. They hadn't gone at him and not been able to get him yet, though. It was a very quick, very clean, a very tidy operation as far as those types of things go. Eventually, the general took sanctuary in the Papal Nunciature in Panama City, where he apparently hoped to be granted political asylum. Noriega's presence in the Papal Nunciature touched off a diplomatic impasse in a round of intense negotiations involving several countries. Vatican officials initially refused to turn Noriega over to the United States. While he was still ensconced in the Nunciature, American troops stationed outside pelted the building with loud rock and roll music blasted through loudspeakers. It's quite a way they put the pelting. It's quite visual, isn't it? The music was played continuously for 3 days until church authorities protested the action as offensive. So they turned off the music, I guess, at some point. This actually reminds me, it's funny how music gets weaponized. We had when I was living in Walla Walla, there was a park downtown that used to be downtown Walla Walla used to be like terrible when I was in college there. Very rundown, old boarded up storefronts and stuff like that, and it's since been completely revitalized. Like we're one of the few places in the U.S. where the downtown put them all out of business. But back at the time, it was not a very good place, and so there was this park that you would kind of be just a lot of not so good stuff going on in that park at night. And so they use this very similar method, but instead of pelting the rock and roll, they played opera. And they played opera at night in the park, and I guess the goal was to discourage the meth heads. I don't know how well it worked, but I don't think they do it anymore. Anyway, after an 11-day standoff, Noriega finally surrendered to American forces, apparently under pressure from the papal nuncio and influenced by a threatening crowd of about 15,000 angry Panamanian citizens who had gathered outside the residence. On January 3rd, 1990, 2 weeks after the invasion began, Noriega walked out of the papal nunciature and surrendered himself to U.S. military officials waiting outside. He was flown by helicopter to Howard Air Force Base, where he was ushered into a plane bound for Florida and formally arrested by agents of the Drug Enforcement Agency. During the course of this litigation, which has included several hearings, no evidence was presented nor suggestion made that Noriega was in any way physically mistreated. Haven't heard anything about that vis-a-vis Mr. Maduro. He had several changes of clothes. Didn't seem to have injuries or anything like that. He was brought into court pretty quickly after he arrived in the United States. Nothing that we know of at this point. Now, Celia, I understand, might have had a black eye, so we'll see how that fleshes out. As is evident from the unusual factual background underlying this case, the court is presented with several issues of first impression. This is the first time that a leader or de facto leader of a sovereign nation has been forcibly brought to the United States to face criminal charges. So it's kind of nice when there's a precedent, right? Because that's what we're dealing with now. So the fact they had to do this before is kind of helpful. The fact that General Noriega's apprehension occurred in the course of a military action only further underscores the complexity of the issues involved. In addition to Defendant Noriega's motion to dismiss based on lack of jurisdiction over the offense and sovereign immunity, defendants Noriega and Del Cid argue that they are prisoners of war pursuant to the Geneva Convention. This status, the defendants maintain, deprives the court of jurisdiction to proceed with the case. Additionally, Noriega contends that the military action which brought about his arrest is shocking to the conscience, and that due process considerations require the court to divest itself of jurisdiction over his person. Noriega also asserts that the invasion occurred in violation of international law. Finally, Noriega argues that even in the absence of constitutional or treaty violations, the court should dismiss the indictment pursuant to its supervisory powers so as to prevent the judicial system from being party to and tainted by the government's alleged misconduct in arresting Noriega. The court examines each of these issues in turn below. So that's quite a mouthful, isn't it? There's a lot going on in here. And again, we already know that there's going to be a lot of overlap with Maduro. He said in court, "I'm the president of Venezuela. I consider myself a prisoner of war." They, invoked the consulate. He gets his visit from the consulate because there's these, diplomatic considerations and so forth. And so we can kind of see probably where this type of thing is going. It's the same situation in so many different respects, and so we kind of have a roadmap here for how the court might have to grapple with these complicated issues that come up. So We're going to look now at how the court handled them, and that should maybe give us some idea about how it could be fleshed out in Maduro's case. Now, again, got to highlight, this is a district court decision. This is not in and of itself prejudicial. The Southern District of New York doesn't have to follow this. Southern District of New York isn't in the 11th Circuit either, so they don't necessarily have to follow the 11th Circuit that affirmed this decision. But it does nevertheless give us a framework for kind of how these arguments are likely to be presented, and some of the sides, I guess, of the issue that are almost certainly going to be fleshed out. So I'm going to skip this part that's dealing with jurisdiction over the crime, because it's basically saying, how are you going to charge me with a crime in the United States when my conduct was all in Venezuela? And the bottom line, or not Venezuela, but in this case it was Panama. And the bottom line was that the court just basically says, look, if your activity is creating effects in the United States, that's both national and international law are going to allow that to be prosecuted in the United States. It's the later sections where it starts to get interesting. And so this one right here, sovereign immunity, this is potentially going to be a big one. The court next turns to Noriega's assertion that he is immune from prosecution based on head of state immunity, the active state immunity, and diplomatic immunity. So 3 different doctrines that he's arguing don't allow him to be prosecuted in a U.S. court. So first, head of state community, grounded in customary international law, meaning it's not a treaty or anything that's out there that people have signed and bound themselves that can be, enforced in The Hague or anything like that. This is custom. This is how things have been done for a long time. It's one of the sources of international law is just kind of how things are done. The doctrine of head of state immunity provides that a head of state is not subject to the jurisdiction of foreign courts, at least as to official acts taken during the ruler's term of office. The rationale behind the doctrine is to promote international comity and respect among sovereign nations by ensuring that leaders are free to perform their governmental duties without being subject to detention, arrest, or embarrassment in a foreign country's legal system. Governments get into conflict sometimes, and just with the relationships that, say, in the United States, where we have Congress has authority over certain things and the executive has authority over certain things. And so Congress, theoretically can provide for certain things to be done. And it's the duty of the executive and the executive branch to faithfully carry out the laws as Congress adopts them. And this is where you run into these real difficult political hornet's nests over who exactly has authority over what, what's the scope of each one's power to act. But you can kind of imagine in this framework a situation where, let's say, Congress declares war on a foreign country, let's just pick Syria. Congress declares war on Syria. The president has an obligation to carry that out. He's got control over the strategic and tactics and things like that. He's the head of the armed forces. But not real clear he would be able to just totally ignore that and not do anything. So at least in theory, president has a duty to carry that out. Well, Syria might, be offended by that, and Syria might consider it, criminal for him to do something like order troops onto Syrian territory. So, Syria came in and grabbed him and prosecuted him. Yeah, we'd probably have a big problem with that. Now, okay, this was a terrible example because declaring war is already not talking about international comity and respect and stuff like that. But in fact, probably a lot of situations are not really talking about international respect. But I can think about situations like the Opium Wars is maybe one where this is back during the British Empire days, and the British Empire is importing massive amounts of opium into China against China law. And this is like a fairly official policy, as I remember. I know everything I know about the Opium Wars from History on Fire from Daniele Bolelli. So if I get anything wrong, it's totally his fault. No, I'm just kidding. It's because I don't remember real specifically. But so anyway, like this, has the potential to create a massive diplomatic crisis. And so you want those crises to be resolved in ways that are, less likely, I guess, to end up in war than just escalation by like going and prosecuting the head of state of the other country. So it makes sense why this doctrine exists, why this policy exists, even if it's just a custom. It would be considered sort of important for turning down the heat in international conflict. In order to assert head of state immunity, a government official must be recognized as a head of state. This seems like a pretty important qualifier. Noriega has never been recognized as Panama's head of state, either under the Panamanian Constitution or by the United States. Well, we have recognized Maduro as the president of Venezuela in the past, but pretty sure as of 2019, it's not just us, by the way. It's the UN. It's like a lot of countries and global organizations did not recognize Maduro as the legitimate president of Venezuela. Basically, he lost the election and refused to hand over the reins of power. So it's kind of similar, but also kind of different, because Noriega was purely de facto, right? There's nothing in his position that gave him even sort of technicality type of argument to being the actual head of state of Panama. Maduro, it's a question of legitimacy and who has the power to decide, who has the power to recognize him as head of state or not, and to what extent do we, outsiders get to second guess the decision from the Venezuelan government on the grounds that, hey, the Venezuelan government doesn't seem to be following its own rules and isn't representing the democratic will of the people that it's supposed to constitutionally. Kind of a complicated question, isn't it? Is Maduro going to count as the head of state or not? So they just go into some details here that he was never elected to head Panama's government. In fact, abrogated the Panamanian presidential elections of May 7th, 1989. So they didn't even have elections, just no elections. It was kind of not really a coup, I guess, but more like just a military government. More importantly, the United States government has never accorded Noriega head of state status, but rather continued to recognize President Eric Arturo de Valle as the legitimate leader of Panama while Noriega was in power. We didn't recognize Maduro as legitimate, but I'm not sure. Did we formally decide that I think it was Gonzalez who won the election? Did we decide he was the real president of Venezuela and recognize him? I kind of don't think we did. Because part of the problem is that for purposes of being able to deal with a foreign government, they have to be able to have some influence over what's happening in the country. And so it's kind of an illusion to deal with somebody as a head of state if, for example, they're living in exile, don't have any ability to influence the course of events that are happening on the ground in that country. I don't recall if we did or not. So that might be a distinction here, not totally clear. So, as this court held in a previous case involving the Republic of Panama, the executive's decision to recognize President Del Valle and not the defendant as Panama's head of state is binding on the court. This is going to be a political decision doctrine issue. The court is going to say that's not our pay grade to decide. That's a matter of diplomacy. That's a matter for the executive and potentially Congress to some degree to make those decisions. So that same restraint is likely going to be applied in Maduro's case. They're not going to be the ones deciding for themselves is he the legitimate president of Venezuela or not. They're just going to look at what formally has our government done in terms of recognizing somebody else, recognizing him, and then giving deference to that decision. Discretion foreign policy decision committed to the executive branch and thus conclusive upon the courts. So, aside from the fact that neither Panama nor the United States recognizes Noriega as head of state, the defendant concedes he does not fit within the traditional notions of a head of state as defined by customary international law. Now we're back to customary international law. It's going to come up if you're dealing with a foreign head of state or even a putative foreign head of state. He nonetheless argues that he is entitled to head of state immunity as the de facto ruler of Panama, regardless of the source of his power or the nature of his rule. That's potentially Maduro's situation. You could say he's not the legal president. He wasn't duly elected. He's not rightful. He's not legitimate, but he still held the reins. He still lived in the presidential palace. He still ran the government. He just didn't do it rightfully, so to speak. So it would make him the de facto ruler. In fact, this court has previously acknowledged that despite the official recognition of Del Valle, Noriega was the de facto head of Panama's government. But simply because Noriega may have in fact run the country of Panama does not mean he is entitled to head of state immunity, since the grant of immunity is a privilege which the United States may withhold from any claimant. Well, that's got a citation that supports it, an old one all the way back to 1812. But that's now distinct from the customary international law, isn't it? They've said basically this exists as a matter of custom, but as a matter of U.S. law, we don't have to grant it to you. And that does make sense. I mean, immunities are typically protections from prosecution that derive from the sovereign. And so if the sovereign, doesn't have any authority to kind of decide whether to follow it or not, then that's not really a sovereign. That means the sovereign is subject to something else. And that's just not really consistent with how we tend to view government power. I mean, whether on the national level or even really on the international level. Because states grant immunity from their jurisdiction as a privilege, the United States, this is a parenthetical, the United States would not extend immunity to officials of governments with which it does not have diplomatic relations. Indeed, deference to the executive branch in matters concerning relations with foreign nations is the primary rationale supporting immunity for heads of state, since the only reason Noriega would be entitled to immunity as a head of state is because of such judicial deference to the executive. His claim to a right of immunity against the express wishes of the government is wholly without merit. So it seems, as long as the New York court follows the same rationale of the Southern District, the Florida District here, then it doesn't seem real likely that this, whether I'm legitimate or not argument would work to grant him immunity. The court is essentially going to say it's up to the executive to decide who the head of state is of Venezuela and what sort of respect that person gets in the courts. And so kind of by virtue of the fact that they've brought you in here for prosecution through the executive's Department of Justice tends to show they don't intend for you to have that type of privilege. The head of state argument comes to the court unencumbered by evidence. The arguments were made largely on the basis of general information made available by the media. However, accepting as true statements of counsel regarding defendant's position of power, to hold that immunity from prosecution must be granted regardless of the source of power or nature of rule, would allow illegitimate dictators the benefit of their unscrupulous and possibly brutal seizures of power. Kind of an important policy, isn't it? No, you can't prosecute Pol Pot because he's the head of government. I don't know that we necessarily want to do that. Yeah, seems like that wouldn't be real American. No authority exists for such a novel extension of head of state immunity, and the court declines to create one here. Since the United States has never recognized General Noriega as Panama's head of state, he has no claim to head of state immunity. So that argument is out. Now, is it going to be enough that the US at one time recognized Maduro as the president of Venezuela, but doesn't currently recognize him? Under this reasoning, probably not. No, because it's the same kind of idea. If he doesn't rightfully hold power, then the means by which he held it were potentially vindicating that and giving him special privileges because of the fact that he was able to lead up this oppressive regime. And that's not really the kind of thing that we want to encourage, is it? So to the extent that it's the executive that gets to make the decision about who is legitimate and who isn't anyway, seems to imply the court is going to defer to that. Now, of course, there's Realpolitik and there is judicial realism in all of this. And we can't overlook the fact that, this is a little bit of a different era. This is being decided back in 1990. Here we are 36 years later. And we have, I don't know, maybe a little different understanding, different politics surrounding executive power, a little bit more of a sense of a slippery slope, maybe. Because this is fairly absolute in terms of the deference that's given, and there's going to be a lot of people who will look at that type of framework and say, but you can't do that in this era because there's no law that governs the president's decision about who's legitimate or not. So what would stop the president from just deciding, for example, I don't think whoever, Putin, is a legitimate head of state. We're gonna charge him with crimes. We're gonna go in and kidnap him. We don't necessarily have a good case that he's not the head of state, at least not that I know. I mean, pretty sure we still recognize him as the head of state. But so could the president just decide, you know what? I don't like the labor leader who gets elected to the prime minister in the UK right now, so I'm just not going to recognize. I mean, he's not the head of state, of course, the king is, but it's like it gets complicated with the UK. I realize constitutional monarchy, yes, they don't have any real actual power, but figurehead of the government, whatever. But I don't even know actually who counts as the head of state for this type of purpose in the US, whether it would be the prime minister or the monarch. But it's just you get my point. If it's entirely in the discretion of the executive, then there doesn't have to be any reason for it. It could be arbitrary because the remedy for that is going to be political. Vote a new president in. So, yeah, possibility that this reasoning might not be so expansive in the current era just because of the much more polarized political environment that we live in relative to 1990. 1990 is the original Bush. Remember, original George H.W. Next up, the act of state doctrine. Noriega next argues that the act of state doctrine prohibits the court from adjudicating the legality of his official actions in Panama. Unlike head of state immunity, the act of state doctrine presents no jurisdictional question, but instead addresses the court's permissible scope of inquiry into certain governmental acts. It is more properly understood as an issue preclusion device rather than an immunity prohibiting prosecution. The classic expression of the doctrine is stated, every sovereign is bound to respect the independence of every other sovereign state, and the courts of one country will not sit in judgment on the acts of government of another done within its own territory. This goes back to 1879. You know, this is another one that's maybe a little hard to hold on to in this day and age because we've seen a lot of oppressive governments. This is, you know, pre what happened during World War II in the camps. This is pre what happened in the Cambodian killing fields. This is pre what happened in the Holodomor over there in the Ukraine. I mean, it just, you know, the list goes on and on and on of the kinds of government atrocities that have been carried out. And are we really going to not sit in judgment on them, not do anything about them? Just this is absolute kind of non-interventionist type of position. I don't know the answer to that. It's really super complicated because it's such a balancing act between, of course, you don't want to be the world police, you know, out there up in everybody's business, telling everybody how to do things. That's not a good state of affairs, but neither is just complete go forth and slaughter your people. You won't get any trouble from us. Surely there's going to be some point where the majority would agree, look, this is intolerable and something has to be done. Maybe not. I don't know. But I kind of question the viability of this particular principle as it's been stated so unequivocally. More than 60 years later, the Supreme Court reaffirmed the doctrine in Banco Nacional de Cuba versus Sabatino, in which the court refused to examine the Cuban government's taking of property in Cuba owned by a Cuban corporation without compensation. So then there's just another bunch of cases, parentheticals about allegedly illegal activities in foreign countries. Although stated in terms of acts of the state or sovereign, the doctrine also extends to governmental acts of state officials vested with sovereign authority. Whether such officials and their governments need be recognized or accepted as such is unclear. The court in Underhill held that the act of state doctrine cannot be confined to lawful or recognized governments. The immunity of individuals from suits brought in foreign tribunals for acts done within their own states in the exercise of governmental authority, whether as civil officers or military commanders, must necessarily extend to acts to agents of government ruling by paramount force as a matter of fact. So legitimacy doesn't necessarily matter because if the issue is simply whether this is an act of the government or not. So an example would be, let's say in this conspiracy that's alleged against Maduro, he's alleged to have allowed, you know, trafficking of cocaine through Venezuela, use of the Venezuelan ports and so forth. Let's say that Venezuela maybe you know, the military at the border intercepts a load or something, intercepts a shipment of narcotics, and Maduro orders them to stand down and allow it to pass through. Now, he's only got the ability to make that order because he's the president, or at least the putative president. And so he's got the power that, not clear anybody else would have that. At least they wouldn't be able to veto him. Maybe like a governor or a general or somebody would be able to do the same thing. But not just anybody, right? You're going to have to be a specific person within a specific chain of command to be able to carry that off. So it's because you occupy that official position of power that you're able to move the levers of government to carry out the outcomes that you're looking for, even if those outcomes are facilitating criminal activity. That seems to be what this is saying. But Sabatino, however, indicates otherwise. The judicial branch will not examine the validity of a taking of property within its own territory by a sovereign foreign government, extant and recognized by this country at the time of suit. Resolution of the two cases is unnecessary at this time, however, in light of the court's disposition below. So basically, they're saying there's this conflict in law between do you have to have a legitimate government, or do you just have to have power over the levers? Not real clear. Doesn't apply in this case, though, because in order for the active state doctrine to apply, the defendant must establish that his activities are acts of state, i.e. that they were taken on behalf of the state and not as private acts on behalf of the actor themselves. So now we have this fine distinction. It's not just the fact that you were in the position to order the military to stand down. It's what was achieved by that. Was this some sort of official policy? Was this something that is done for Venezuela as a whole? Or is it just something that you're doing because you're in the position to facilitate it being done, but nobody is benefiting from it besides you? So, I mean, I guess it's kind of the distinction between, you can have different hats on and doing different things. Like you can be a senator, you can be a senator in the United States. And, as a senator, you can send out mailings, but are those mailings acts of state when they involve your political campaign? No, they don't. Now, this is probably not a good example because, anybody can send out mail. You don't have to be a senator to be able to do that. But, an example just might be things like, the relationships that you form. You can meet foreign leaders, you can meet foreign business people, you can chit chat with them. So I don't know if you made an introduction or you hosted a dinner or you paid money or something like that to a foreign leader that you only got access to that person because of the fact that you're a senator. But what's actually happening is that, you're laying the groundwork for a little quid pro quo, a little, once you're no longer in office, they're going to come hire you to be their registered foreign agent and lobby for them and stuff like that. Does that make it an act of state? Probably not. Again, not necessarily legal, but if you're not doing it for the benefit of the country, then it's not going to count. I think the challenge here is that there's going to be a lot of overlap, and there's going to be the potential to be able to try to justify things under multiple justifications. Not everything is black and white, and not everything is always clearly this and not that. People can benefit themselves and also benefit the government. It's not like it's always universally one or the other. So I think a lot just is going to depend on the specific facts and what exactly is being alleged as the act at issue, and how much does it implicate any kind of broader activity within Venezuela, within the government, within the state, within the budget. I mean, all that stuff versus Is this just he had an opportunity to line his pocket and used his power to be able to make that happen? The court fails to see how Noriega's alleged drug trafficking and protection of money launderers could conceivably constitute public action taken on behalf of the Panamanian state. Certainly no evidence has been presented to this effect, despite defendants' burden of proof on the issue. So I do think this is important because this was raised, you remember he said up at the beginning, this was raised before Noriega was ever arrested. He had the special appearance by a lawyer, came in and made these arguments kind of as a matter of law, and they just relied on news articles and stuff like that. We don't have that situation here. They are going to potentially have the opportunity to be able to put on evidence. And so it seems like that might be able to muddy the waters just depending on what there is. You know, how did this money move? I have to imagine in a narco trafficking type of case, there's going to be a lot of evidence about how the money moved. Seems like that's going to matter. You know, if drug money is helping to fund Venezuelan government operations, then it seems a lot more likely that it's going to fit within this action taken on behalf of the state. If it's completely separate and the two like never really meet, then it's a lot easier to just point it at, obviously this wasn't for Venezuela because it never touched the people, it never touched the state. Is it real likely to be super clear one way or the other? I mean, I don't know. Can't say I have a whole lot of personal experience in like financially auditing a narco government. So just kind of highlighting here that it was maybe an easy question in this state because they didn't have a factual record. But Maduro is going to have the opportunity to create a factual record and to try to argue, to try to establish that this wasn't just my personal thing. There were benefits to the Venezuelan state. I don't know what that could be, but just the potential is there because of the difference in the posture of these two cases. The indictment in this case charges a series of private acts committed by the defendant for his own personal financial enrichment. It does not allege, and cannot reasonably be construed to charge, that Noriega participated in a racketeering enterprise and conspired to import cocaine into the United States in furtherance of Panama's state policy. Got an issue with my mic here. Or to serve some overriding national interest. The fact that Noriega is alleged to have utilized his official position to engage in criminal activity does not, as defendant suggests, cast his actions in a public light. As we well know, government officials are as capable of exploiting their positions of power for private selfish ends as they are for public purpose. The inquiry is not whether Noriega used his official position to engage in the challenged acts, but whether those acts were taken on behalf of Noriega instead of Panama. Here's where I could see this getting complicated. What if it's part of the official policy of the Venezuelan government to undermine the United States? And that facilitating the narco trafficking in the region is beneficial to that. It serves to help introduce instability into the United States. Like as a matter of foreign policy, this is part of the objective. I could potentially see something like that. I don't know. But it seems like that could be an issue, couldn't it? If it benefits the state in some way, then it's a lot harder to say, well, it's just his personal actions for his own benefit. I don't know what that's going to be, but it's going to be something to watch. See how that comes out. Defendant does little more than state that as the de facto ruler of Panama, his actions constitute acts of state. The sweeping position completely ignores the public-private distinction and suggests that government leaders are, as such, incapable of engaging in private official conduct. It's l'état c'est moi. L'état c'est moi. That was Louis XIV, the Sun King. I am the state. I am the state. When you have an absolute monarchy, that's almost certainly the case, but in most even ostensibly democratic representative forms of government, yeah, you don't typically have that. You do have a more of a distinction between the individual and the role. Aside from its lack of logic, suffice it to say that this argument has been implicitly rejected in several cases, distinguishing the private from public conduct of heads of state and foreign dictators. See some involving the Marcos, former dictator in the Philippines. The notion that Noriega, qua dictator, was essentially the sovereign and that all of his acts are therefore acts of state is most thoroughly undermined by the Jimenez case, an authoritative precedent directly contrary to Noriega's position. In that case, the Republic of Venezuela alleged that Jimenez, its former president and dictator, had used his position to commit financial crimes for his own personal benefit. Jimenez contended that as a dictator, he himself would be the sovereign, the government of Venezuela, and that all his acts constituting the financial crimes with which he is charged are acts of state or sovereign acts. L'état c'est moi. The Fifth Circuit took issue. So he's not the sovereign government, he's the chief executive, even when you're a dictator. They were for his personal benefit, common crimes, in violation of his position and not in pursuance of it. I'm not going to read that last line because, yeah, I'm not going to get into that argument. No fundamental difference separates this case from Jimenez, nor is the court persuaded by the Ninth Circuit's decision in Marcos 2, Supra, upon which the defendant heavily relies. The court in that case, this is going to be different, right? They're distinguishing it. The court in that case held that deposed dictator Ferdinand Marcos's alleged theft and conversion of property and funds belonging to the Philippine Republic were acts of state, since they are activities that Marcos could only have undertaken pursuant to his powers as president of the Philippines. So this, out of the Ninth Circuit, was taking a more just levers of power type of approach to answering this question. Is it an act of state? Well, were you in the position to have the power to make the state do what you wanted it to do? In a lengthy dissent, Judge Nelson persuasively argued that the majority opinion effectively eviscerated the public-private distinction by providing blanket protection to all of Marcos's acts during his reign. On rehearing en banc, which occurred after defense counsel's brief was submitted, the Ninth Circuit reversed this aspect of its decision and essentially adopted Judge Nelson's position, holding that Marcos had not established that the alleged thefts were public acts. So we just had a timeline issue. Defendant gets this decision involving Marcos out of the Ninth Circuit, uses that in their brief, relies heavily on it. The Ninth Circuit then rehears it en banc and changes its mind. So that is a bad position to be as a litigant. It tends to undermine what you're coming from, that the court no longer adopts the legal position that you have relied on. As the court stated, our courts have had no difficulty distinguishing the legal acts of a deposed ruler from his acts for personal profit that lack a basis in law. Marcos 2 is thus of no precedential value on this question. So this isn't, I guess, that unique a situation, having to sort out these types of questions. And I guess it does make some sense, because even though, no, we don't every day go into foreign governments and, foreign states and seize their government officials and bring them to the U.S. for prosecution, it's going to come up, I would think, in context of just people having property here, right? Because property can be subject to judgment, subject to enforcement, subject to forfeiture, all these different types of things. So I don't know the context of the Marcos cases, but yeah, seems I guess it's really not that uncommon to have cases against foreign leaders. Yet another consideration counsels against application of the active state doctrine to this case. Although originally couched in terms of sovereign immunity, the doctrine as presently developed does not rest on principles of international law or respect for sovereign independence. More recent interpretations of the doctrine instead emphasize the separation of powers rationale, more specifically, the need to preclude judicial encroachment in the field of foreign policy and international diplomacy. This is the judicial restraint. Judges are not foreign policy officials. They're not elected, to be accountable in international relations. They aren't part of the committees. They don't have the intelligence clearances, like all of the things that go into having a foreign policy very removed from the courts. And so there's going to be a lot of restraint about second guessing those judgments. In questioning the validity of acts of foreign states, the judiciary may well hinder the executive's conduct of foreign affairs and the need to speak with one voice on the world stage. No such danger is present here, and in fact, the opposite is true, since the executive's position is amply demonstrated by its decision to indict and prosecute the defendant. So the same thing that we have with Maduro. It's an executive branch, the Department of Justice, that is bringing him into court in the first place. And so their position on a lot of these issues, if this rationale is followed, the court's just going to defer to it. Second guessing it would be the court doing foreign policy for us. And, for lifetime appointed judges with no background in these issues, no expertise, no access to the type of information that the decision makers that, we elect for these types of decisions have access to, that's not going to be a good situation if that happened. So ultimately, the court concludes Noriega has not demonstrated that his alleged drug-related activities were in fact acts of state rather than measures to further his own private self-interest. Absent such showing, the active state doctrine cannot apply. So they did give him like a few different options, which is going to be helpful here since Noriega, they didn't have a factual record. But Maduro is going to have potentially the opportunity to make a factual record to say, look, this was the official policy of Venezuela. And, particularly when you kind of look at what some of the international links there are, right? With Cuba, with Colombia, with Russia, with China, does the narco trafficking relate to any of that, any of those relationships in any way? If it does, might be a little bit easier to argue this is state policy. So we'll wait and see how that fleshes out. Diplomatic immunity. Noriega concedes at the outset that his assertion of diplomatic status does not fit within the confines of either the Diplomatic Relations Act or the Vienna Convention on Diplomatic Relations, the two bodies of law governing diplomatic privileges and immunities. Among other deficiencies, the government of Panama never requested that Noriega be accredited as a diplomat, and the U.S. at no time granted him such status as required by the convention. I sincerely doubt that we have made Maduro a diplomat, at least recently. Maybe back in the day when we considered him a legitimate president, but once we decided he was no longer legitimate, I kind of seriously doubt we invited him to take on that type of status. In this case, Noriega was neither eligible nor present in this country as a diplomat. So he relies principally on the fact that he traveled on a Panamanian diplomatic passport and was on 3 occasions granted an A2 visa by the United States. The Panamanian diplomatic passport, it's up to them. It has nothing to do with us. So that's not going to affect the status that he has in the United States. They are without significance in international law and United States law and do not by themselves entitle him to any internationally or domestically protected status. So the A2 visa did not establish anything significant in the way of diplomatic immunity. It's in administrative action in connection with U.S. immigration law, independent of the process of diplomatic accreditation. These seem like issues that are fairly specific to Noriega. You know, maybe there are issues like that dealing with Maduro, but I'm not sure. I'm going to Google real quick. Because I'm just curious. So he has been to the US before, apparently. It says he's made 4 visits to the United States during his presidency. See if I can find out when they are. Back in 2014. So that was when we were still formally recognizing him as president. In 2015, same. 2018, 26th of December. I don't know if that's before or after we recognized him. And well, they're counting. Thank you, Wikipedia. Wikipedia is counting January 3rd of 2026 as a visit. I don't think that's going to count. So the 2018 is the only one that seems like it might be a bit of a question. I don't remember what was state of Venezuelan in yeah, it was 2019. It looks like January 10th of 2019. So all of his official visits, it looks like, were oh wait, no, the election was in 2018. In February 2018, he called for presidential elections. He was declared the winner in May 2018 after multiple major opposition parties were banned from participating, among other irregularities. He wasn't inaugurated until January 10th of 2019. He was pressured to step down by nations and bodies, including the Lima Group, the United States, and the OAS. There were calls to establish a transitional government. So I wonder what day. Yeah, I don't know. January of 2019 is what this report from the Congressional Research Project says, that in January of 2019 is when the US stopped recognizing Maduro as the legitimate president. So basically, that is looking at the time when he was sworn in, not after the election. So the 2018 one is like in this kind of hinterland where it's after the election that we're saying wasn't valid. I guess it would still be during his prior term. So if he had any kind of like diplomatic status during that term, it would be okay. But after January 19, we stopped recognizing him as the legitimate president of Venezuela. So that's like the only thing I could see maybe, fitting into a framework like this. We had allowed him to travel to the United States. We probably gave him some type of visa, but it doesn't seem like it would matter. It doesn't give diplomatic immunity, and it being like well after the fact as well seems that it would not really apply. Now we get into the prisoner of war status. So these were all dealing with, the previous ones were dealing with his status as putative president. The whole idea of being able to prosecute a foreign leader. In all of those arguments as to Noriega, it failed, but we've got potentially some factual differences. We've definitely got a procedural difference. But I think the biggest ones being that Noriega never was, even ostensibly, constitutionally, the head of state. Maduro was at one point, but then stopped having that recognition. Chances are pretty good the court's going to defer to the executive on that decision. So it's probably not going to be the head of state. Acts of state, though, might be a little bit more complicated, just depending on how the facts come out. Noriega, he didn't present any evidence, so we didn't have any real facts to decide it on. Maduro is going to have a different opportunity to be able to do that. This one, now we already know, because he said in court at his first appearance, I'm a prisoner of war. I consider myself a prisoner of war. So this one's probably coming. Let's take a look at it. They contend that they are prisoners of war within the meaning of the Geneva Convention relative to the treatment of prisoners of war, a status defendants maintain, which divests this court of jurisdiction to proceed with this case. For purposes of the motion at bar, the government does not maintain that defendants are not prisoners of war, but rather argues that even were defendants POWs, the Geneva Convention would not divest this court of jurisdiction. So they're saying, yeah, sure, go ahead and think of them that way. It doesn't matter. Government saying it doesn't matter if they're prisoners of war. Thus, the court is not presented with the task of determining whether or not defendants are POWs under Geneva 3, but proceeds with the motion at bar as if defendants were entitled to the full protection afforded by the convention. The defendants' arguments under the Geneva Convention are grounded in Articles 82, 84, 85, 87, 99, and 22, each of which is examined and turned below. So we are not going to go through each and every one of these. The bottom line here is just basically going to be that most of these provisions are dealing with how you are treating somebody in their capacity as a prisoner of war. But being a prisoner of war doesn't exclude them from also being a criminal defendant in a civil court. And so the things that you have to guarantee them, as prisoners are not necessarily exclusive of also being able to prosecute them. So just seeing if there's anything in this that jumps out real quick that we should jump on. The fact that the acts were committed before, if you committed a crime while you're a POW, that's going to be covered under the Geneva Convention, but these were things that preceded it, so it doesn't. No ex post facto laws and coerced confessions, and we also do that in the U.S., so it's not really a problem. And so generally, this is the one that was really the most interesting, right? This Article 22, prisoners of war may be interned only in premises located on land and affording every guarantee of hygiene and healthfulness, except in particular cases which are justified by the interest of the prisoners themselves. They shall not be interned in penitentiaries. Prisoners of war interned in unhealthy areas or where the climate is injurious for them shall be removed as soon as possible to a more favorable climate. The detaining power shall assemble prisoners of war in camps or camp compounds according to their nationality, language, and customs, provided that such prisoners shall not be separated from prisoners of war belonging to the armed forces with which they were serving at the time of their capture, except with their consent. So it kind of seemed to be a problem for holding somebody in the MDC, right, with American criminals, not with their fellow Venezuelans who were captured during the same raid and so forth. So defendants maintain that Article 22 deprives the court of personal jurisdiction by requiring that they be returned to Panama and detained along with other Panamanian prisoners of the armed conflict. The court perceives no such requirement in Article 22, which relates to the general conditions and not the location of internment. The provision upon which defendants rely states that prisoners shall not be interned with persons of different nationality, language, and customs, and shall not be separated from prisoners of war belonging to the armed forces with which they were serving at the time of their capture. According to defendants' interpretation, Article 22 would require that all prisoners of war from the same armed forces be interned together in a single prisoner of war facility. Yet this clearly cannot be Article 22's intent, since internment under those conditions would likely violate its overall concern for healthy and comfortable conditions of internment. Indeed, defendant Noriega undercuts his own argument by suggesting that he be detained in an agreeable third country, an action which would certainly separate him from members of Panama's armed forces being detained in Panama. The more obvious interpretation of the provision is that it prevents prisoners belonging to the armed forces of one nation from being forcibly interned with prisoners from the armed forces of another nation. Such is not the case here. So basically, they're not putting you in a camp with prisoners of war from another country. You're in jail on criminal charges. It's basically saying it's apples and oranges. Moreover, nothing in Article 22 or elsewhere prohibits the detaining power from temporarily transferring a prisoner to a facility other than an internment camp in connection with legal proceedings. That's kind of the catch-all, isn't it? Like, just because you're a prisoner of war doesn't mean we have to keep you in a prisoner of war camp, only have you in the prisoner of war hat. You can be a prisoner of war and a criminal defendant. And while you're being dealt with as a criminal defendant, this is the argument anyway, you can be detained in the same way that other criminal defendants are detained. Because the convention contemplates that prisoners of war may be prosecuted in civilian courts, it necessarily permits them to be transferred to a location that is consistent with the orderly conduct of those proceedings. It is inconceivable that the convention would permit criminal prosecutions of prisoners of war and yet require that they be confined to internment camps thousands of miles from the courthouse and quite possibly defense counsel. All sides of them to be concerned about that because, that would be an issue if you're being detained, in, Guantanamo. Little hard to get access to your lawyer there. The remaining provisions of the convention cited by defendant Noriega lend little, if any, support to his argument regarding jurisdiction. So Article 12, he says, requires him to mandates his removal to a third country, in fact, limits the ability of the U.S. to do that. And Article 118 requires prisoners of war to be released and repatriated without delay after the cessation of hostile activities. But that provision is limited by Article 119, which provides that prisoners of war against whom criminal proceedings for an indictable offense are pending may be detained until the end of such proceedings, and if necessary, until the completion of the punishment. So it seems that the Geneva Convention recognizes a distinction between criminal prosecution and just literally holding somebody because you captured them during wartime and you're not going to release them back to their country to, continue taking up arms against you again until the hostilities are over. So as long as you're going to hold them for no reason other than they're an enemy soldier, you have to treat them in accordance with these requirements of the convention. But it doesn't preclude you, apparently, from being able to subject them to criminal prosecution. So no real issue with their being, prisoner of war status. It's kind of a big who cares, according to this district court. Extradition treaty between Panama and the United States. Defendants argue that Geneva III operates to divest this court of jurisdiction over defendants because they could not have been extradited from Panama to the United States for the crimes with which they are charged. The genesis of defendants' argument is not in the language of the convention, but is rather found in the Red Cross commentary on Geneva III, which in discussing Article 85 states that, in general, Acts not connected with the state of war may give rise to penal proceedings only if they are punishable under the laws of both the detaining power and the power of origin. As a parallel, reference may be had to extradition agreements or to the customary rules concerning extradition. Extradition requires both sovereigns to agree to it, and as soon as one of them doesn't, the extradition doesn't happen. And that's just kind of one of the costs of sovereignty that we recognize. An act in respect of which there could be no extradition should not be punished by the detaining power. One may also examine whether prosecution would have been possible in the country of origin. If the answer is in the negative, the prisoner of war should not be tried by the detaining power. So first, this isn't law. It's a commentary. It's a discussion regarding what the author believes should be done or not done as a matter of policy. It's not part of the treaty. The text of the treaty itself doesn't limit the jurisdiction of domestic courts to extraditable defenses. And the Supreme Court has held that in order for an international treaty to divest domestic courts of jurisdiction, the treaty must expressly provide for such limitation. So they're not going to infer that Congress, adopted a treaty, ratified a treaty that gives up jurisdiction of the United States unless it explicitly says so. You're not going to read between the lines and think that that's what they meant to do. No, they're going to require that to be put in clear language. Moreover, the commentary itself does not support defendant's position. It may serve as a guiding reference in determining what acts should be punishable. His entire argument is premised on the observation that the act of narcotics trafficking is not one of the 13 crimes listed in the extradition treaty between Panama and the U.S. Defendants overlook, however, the fact that the narcotic offenses with which defendants are charged are not only constitute the kinds of offenses which could be the subject of extradition under customary international law, but are specifically contemplated by subsequent treaties between the U.S. and Panama. So this is going to be specific to them. Don't know what the status is of any extradition treaty between the U.S. and Venezuela and what it says vis-a-vis narco trafficking or whatever. Again, there's this kind of conflict between, we do have an extradition treaty with Venezuela. If I remember correctly, it dates back to like the 1920s. But you then have a subsequent revolution in Venezuela and an adoption of a Venezuelan constitution, which kind of, at least to some extent, seems to abrogate that treaty by providing that Venezuelan citizens shall not be extradited. Like it's very explicit. So that seems to be a little bit unclear. But it seems like in this particular situation, the court would likely err on the side of the Red Cross commentary is not law, and because unless the Venezuela extradition treaty specifically says the U.S. only has jurisdiction to prosecute if they follow these proceedings, and that isn't treated as like null and void by the Venezuelan adoption of a constitution that seems to abrogate it, then I think it's going to be the same type of argument here. They're not going to accept that criminal prosecution is just limited to extraditable offenses. Illegal arrest. Now we're getting into stuff that's like maybe a little bit more familiar and close to home because it's not limited to, international heads of state. It's not really that complicated. Anybody can be arrested illegally. So what's the implication of that? Noriega also moves to dismiss the indictment on the ground that the manner in which he was brought before this court as a result of the United States government's invasion of Panama is shocking to the conscience and in violation of the laws and norms of humanity. He argues that the court should therefore divest itself of jurisdiction over his person. In support of this claim, Noriega alleges that the invasion of Panama violated the Due Process Clause of the Fifth Amendment of the U.S. Constitution, as well as international law. Alternatively, he argues that even in the absence of constitutional or treaty violations, this court should nevertheless exercise its supervisory authority and dismiss the indictment so as to prevent the court from becoming a party to the government's alleged misconduct in bringing Noriega to trial. He's appealing to the court's need to keep the high ground, to have clean hands. That even if the executive and Congress occasionally engage in some dirty work, right? Because unfortunately, foreign policy and war and diplomacy and all that stuff occasionally does involve some dirty work. The court has to stay above that. And so for them to be involved in sanctioning it or facilitating it or something like that, it's dirties the integrity of the court. And so they should be resistant to doing that. Fifth Amendment due process arguments, can tell you right off the bat, don't even have to read it myself. It ain't going to work. They don't really care if you were illegally arrested. They say your remedy is civil. It is well settled that the manner by which a defendant is brought before the court normally does not affect the ability of the government to try him. The Kerr-Frisbee doctrine, as this rule has come to be known, provides that a court is not deprived of jurisdiction to try a defendant on the ground that the defendant's presence before the court was procured by unlawful means. This court's adherence to the Kerr-Frisbee doctrine was firmly established in U.S. v. Winter, in which the former Fifth Circuit declared, "We are convinced that under well-established law of the Supreme Court and this circuit, a defendant in a criminal trial, whether citizen or alien, whether arrested within or beyond the territory of the United States, may not successfully challenge the district court's jurisdiction over his person on the ground that his presence was unlawfully secured." This is all going back to an idea that the person of the defendant is not a suppressible fruit of an illegal government act. The identity and the person are like exceptions to the exclusionary rule, basically. Now, though, here's something kind of interesting, because got a little bit of an exception here. Noriega does not challenge the validity of the Kerr-Frisbee rule, but instead relies on what is commonly referred to as the Toscanino exception carved out by the Second Circuit. Why does this matter? Because the Southern District of New York sits in the Second Circuit. The district court in which Maduro is being tried, the Second Circuit, Toscanino, is binding precedent. It's not in Florida. In New York, they have to follow it. So to the extent that it modifies this rule or creates like a mandatory different way of handling it, Southern District of New York is going to have to go with that. So what does it say? In that case, which also involved a challenge to a court's exercise of personal jurisdiction, the defendant contended that his presence was illegally obtained through torture and abuse. In support of his claim, the defendant offered to prove that the U.S. officials abducted him from Uruguay and subjected him to extensive and continuous torture, including pinching his fingers with metal pliers, flushing alcohol into his eyes and nose, forcing other fluids up his backside, and attaching electrodes to his extremities and genitals. Nice. Confronted with these allegations, the court refused to permit the government the fruits of its misconduct, holding that we view due process as now requiring a court to divest itself of jurisdiction over the person of a defendant, where it has been acquired as the result of the government's deliberate, unnecessary, and unreasonable invasion of the accused's constitutional rights. And so holding, the court relied on the Supreme Court's decision in Rochin versus California, where the due process clause was applied to the whole course of the proceedings in order to ascertain whether they offend those canons of decency and fairness which express the notions of justice of English-speaking peoples, even toward those charged with the most heinous offenses. So, seems like that's pretty factually specific, right? You can't torture somebody and abduct them and bring them over to the United States. Like, if that happened, maybe you're in a different situation. don't really have any indication that that's what happened to Maduro. But I am going to go ahead now and switch us over here to take a little bit of a closer look at Toscanino, because I don't think it's quite that limited. That's certainly the facts of the case. They go through a lot of these details. Basically, he was kidnapped. He was taken to Brazil. Tortured him. While they're torturing him, the prosecutor is like talking to, I don't know if it's specifically the torturers, but like the CIA, getting updates about his interrogation. Yeah, it's kind of awesome. Not awesome. So let me find the part that matters here the most. So it's going through the Kerr-Frisbee rule, but they're pointing out that Kerr-Frisbee preceded the exclusionary rule and the expansion of these ideas of due process. So like Mapp versus Ohio, where they first said illegal search results in the exclusionary rule. Wong Sun, similar type of issue. And so Frisbee, they say, have been eroded. It's been eroded because we have to, there's no right without a remedy. And so there's no point in having these rights in the Constitution that say you can't be unlawfully searched and seized if the police can just do it anyway and then use what they find against you. And that's it. And there's nothing you can do about it. And there's no remedy. If that's the case, you don't really have those constitutional rights. So this was an evolution of the law that came after Frisbee. So they're going through what the Toscanino court interprets as being this kind of new jurisprudence, this new recognition that the problem here is for the prosecution, for the state to exploit illegal conduct, to violate your rights, and then obtain some benefit from that. And so that's what needs to be discouraged, and that's what the kind of core harm of due process is. That's the playing dirty part, is that I'm going to break my own rules to get an advantage, and I'm going to just be allowed to do that. Like, if that's the case, that's not due process. So, in light of these developments, we are satisfied that the Kerr-Frisbee rule cannot be reconciled with the Supreme Court's expansion of the concept of due process, which now protects the accused against pretrial illegality by denying to the government the fruits of its exploitation of any deliberate and unnecessary lawlessness on its part. So, like, while it mostly involves evidence, we have to basically follow the general principle of denying them the opportunity to be able to do that. So here, having unlawfully seized the defendant in violation of the Fourth Amendment, which guarantees the right of people to be secure in their persons against unreasonable seizures, the government should, as a matter of fundamental fairness, be obligated to return him to his status quo ante, before they acted. His pre-existing status, meaning before he was arrested. Accordingly, we view due process as now requiring the court to divest itself of jurisdiction over the person of a defendant where it has been acquired as the result of the government's deliberate, unnecessary, and unreasonable invasion of the accused's constitutional rights. That's the part that was quoted in the Noriega decision. So if these charges of government misconduct and kidnapping him and forcibly bringing him to the United States should be sustained, the foregoing principles would, as a matter of due process, entitle him to some relief. This is why I think it's a little broader than what Noriega court is saying, because they're just focusing on kidnapping him and bringing him into the United States. They're not bringing the torture. The torture is like a bonus, basically. The allegations include corruption and bribery of a foreign official, as well as kidnapping accompanied by violence and brutality to the person. deliberate misconduct on the part of United States agents in violation not only of constitutional prohibitions, but also of the Federal Kidnapping Act and of 2 international treaties obligating the U.S. government to respect the territorial sovereignty of Uruguay is charged. The conduct alleged here satisfies these tests this is an entrapment decision. Here, not only were several laws allegedly broken and crimes committed at the behest of government agents, but the conduct was apparently unnecessary, as the extradition treaty between the U.S. and Uruguay does not specifically exclude narcotics violations, so that a representative of our government might have been able to conclude with Uruguay a special arrangement for Toscanino's extradition. So this is definitely cutting the other direction. This is implying like part of the reason this is so bad is they could have just done this through the official channels the right way. They could have just done it the right way. And instead of doing that, they went in and kidnapped him and forcibly brought him to the U.S. If kidnapping and forcibly bringing to the U.S. is the standard, then we're going to have a potential issue under Toscanino in Maduro's case. Like, there's no question this case is going to be brought up, and they're going to have to decide, one, the scope of it, the scope of this exception. How much does this depend on the fact that they tortured him and did all that other bad stuff versus just these alleged, violations of U.S. and international law and so forth? Because, as we're going to get back to with the Noriega decision, it doesn't seem to be hard to establish that that's going to apply in Maduro's case as well. So we're going to have to deal with, does it apply? And if it applies, then what? Divest of jurisdiction, this court is saying. No power to prosecute. Going back to our putting our Realpolitik and our judicial realism hat back on. Is that going to happen? Is that going to happen? It's hard to imagine that a district court in the Southern District of New York is going to say, yep, sorry, no jurisdiction to proceed. Maduro, off you go, back to Venezuela. Because of the implications of that, right? Everything that we just talked about, as far as the executive has the power to make all of these foreign policy decisions and stuff like that. And that how would that not be the court really doing some major foreign policy on its own behalf? It's hard to see that happening. On the other hand, the judge has got to follow the law. And this is this kind of distinct, unique situation in the Second Circuit where we are trying Maduro, this specific exception. So I could see like a middle ground scenario where the judge says, look, this is what the law says, and I have to apply it. It's out of my circuit. I don't have any choice. But I'm going to stay it. And you government can go appeal it, and it's going to have to go up. That's how I think this might end up getting resolved, is with an early trip up to the U.S. Supreme Court, because they've never looked at this exception. They've never evaluated this. Is this legit? Like, do we accept this or not accept it? So for them to go take a look at the Kerr-Frisbee doctrine and the Toscanino exception and decide if they agree with this reasoning or don't agree with the reasoning. And, it's ultimately kind of what should happen. It should be the high court that makes those kinds of high level decisions. But, yeah. Be very interesting to see. Not real sure how that would go from a kind of, I'm going to say political, even though that's not really the word I mean, political standpoint, but just in terms of what people think of the court and the court's decisions. The Supreme Court is, of course, used to having to make hard calls on difficult questions and piss a lot of people off in the process. But it certainly does have a lot of long-term implications, and also, implications just in terms of, our standing in the world and the extent to which we are regarded as a country of laws and of integrity and things like that. Law that basically says, hey, we can violate the law without consequences, doesn't really put us on the kind of moral high ground footing that the courts usually want to maintain. But there might be hope here, right? Because this type of government conduct necessary to invoke the Toscanino exception and warrant the drastic remedy of dismissal was subsequently clarified and narrowed in this Lujan case. There, the court held that due process is violated and dismissal warranted only where the defendant proves torture, brutality, and similar outrageous conduct. The conduct must shock the conscience. Now, again, don't think we have any particular evidence of Maduro being tortured or anything like that, but we got a military action going in, destroying his entire security, his all of his security guards. Don't know what kind of force was used or needed. We know Celia came out with apparently a black eye, maybe a couple band-aids or something like that. Don't know how she got them. Is it going to rise to the level? I don't know. Brutality? I mean, going in and shooting up the guy's security attachment to take him. Pretty brutal. Is that going to be enough? I don't know. But there's no way that this doesn't get litigated. It's kind of the bottom line. Before addressing the substance of Noriega's claim, the court is faced with the threshold issue of Toscanino's continued validity. So, there's been this subsequent legal development. So this Lopez Mendoza case was a U.S. Supreme Court case where the court held that the body or identity of a defendant or respondent in a criminal or civil proceeding is never itself suppressible as fruit of a unlawful arrest. That's this idea that I was talking about before. Similarly, in Cruz, the court ruled that the defendant could not claim immunity from prosecution simply because his appearance in court was precipitated by an illegal arrest, stating respondent himself is not a suppressible fruit, and the illegality of his detention cannot deprive the government of the opportunity to prove his guilt through the introduction of evidence wholly untainted by police misconduct. This court says those cases are distinguishable from Toscanino, and therefore they don't show that the Supreme Court has undermined Toscanino as the exception. Neither involved the type of inhumane governmental conduct shocking to the conscience to which Toscanino was addressed, and as such merely reaffirmed the general Kerr-Frisbee rule that an illegal arrest without more does not bar prosecution. As Toscanino establishes, there is a difference between conduct which is merely illegal and conduct so egregious it shocks the conscience. We don't really care for our purposes about whether Toscanino applies in Florida because we're going to be in New York where Toscanino definitely applies. So it's going to come up. It's definitely going to be an argument that is raised that there's no jurisdiction to proceed, and they're going to litigate the circumstances of that seizure. I kind of wonder, do you think does Delta Force wear body cams? What do you think? I don't know. This one is going to be super complicated, and so much of this is going to be behind closed doors. So it's not super uncommon for prosecutions to involve classified information, and there's a whole congressional act to deal with discovery in cases where classified information is at issue. If you want an example of this, go look at the John Bolton prosecution that's going on. It makes things super complicated because you basically have to have lawyers that have security clearances, and they got to go to the skiff, to look at the classified stuff, and can't go to the defendant. Like, there's just all these complicated things that go along with it, and so the result is it takes forever. It drags things out real extensively, but also it means a lot of what is presented, what's like at issue in the case, you never get to see. So even if Delta Force does have body cams, you ain't ever going to see them. We're never going to see them. They're going to treat those as classified, treat them as, revealing tactics and methods and things like that. I'd be shocked, if we get to see anything like that. And, I think that is potentially problematic in a case like this. I mean, understanding that there's some stuff that, yes, it would be very damaging to the national security and the national interest for people to see. At the same time, this prosecution and the validity and the integrity of this prosecution is gonna be pretty hotly contested. And so, as we know, the more people can see, the more likely they are to trust the process, because they don't have to just trust it, they get to judge it for themselves. This involves an awful lot of classified information. We're not going to see much of it at all, and it's going to make it hard to trust. And that's just not going to help the overall politicization of the decision to bring him into courts at all. Next, violations of international law. In addition to his due process claim, Noriega asserts that the invasion of Panama violated international treaties and principles of customary international law, specifically Article 2, Sub 4 of the United Nations Charter, Article 20, Sub 17 of the Organization of American States Charter, Articles 23b and 25 of the Hague Convention, Article 3 of the Geneva Convention 1, and Article 6 of the Nuremberg Charter. Here is what's going to matter here. Article 2, Section 4 of the UN Charter talks about, the territorial integrity of sovereign nations, and it needs to be respected. Don't invade your neighbors. Don't dump your trash over on the other side of the border. This is a, transboundary harm kind of principle. Don't do it. But it is important to note that individuals lack standing to assert violations of international treaties in the absence of a protest from the offended government. Violating international treaties, international law, it's not something you have standing to raise. It's not your call. If the government doesn't have a problem with it, then it's not going to matter. So that does kind of put in a little bit of an interesting light what happens in Venezuela, doesn't it? And who gets put in, because you can just see and imagine that certain options are going to be very friendly to the United States course of action down there, not have a problem with it at all. Others might be a little bit more likely to push the issue, take issue with it. But what's that going to mean? Is that going to give this individual, Maduro, standing if the government on his half protests? It kind of implies that they might, but probably not. It's more the type of thing that I would expect is going to implicate, like, international court arbitration action, stuff like that. File a complaint in the UN, and then we're on the Security Council and we'll veto it. So it's like this is where international law is challenging. I heard an expression once that the thing about international law is that it doesn't exist until it does, and that just realistically, pragmatically, that seems very wise to me because it's the truth. Like there's rules, but do they apply or not is a huge, it depends. It's a real big morass. So it kind of implies that, well, if Venezuela went and protested, that maybe that would give Maduro some standing. But no, because the Kerr Frisbee doctrine we already dealt with establishes that violations of international law alone do not deprive a court of jurisdiction over the defendant in the absence of specific treaty language to that effect. So this could create a diplomatic issue on the state level, on the Venezuela-U.S. international relations level, but in terms of giving Mr. Maduro grounds to argue that he can't be prosecuted because it violates international law, even if it does, assuming it does, number one, it's kind of up to Venezuela to decide that or not. But either way, it's not something that he individually gets to hang his hat on. So to defeat the court's personal jurisdiction, Noriega must therefore establish that the treaty in question is self-executing in the sense that it confers individual rights upon citizens of the signatory nations, and that it by its terms expresses a self-imposed limitation on the jurisdiction of the United States and hence on its courts. So again, general principle of international law, individuals have no standing to challenge violations of international treaties in the absence of a protest by the sovereign involved. And it's because treaties are designed to protect the sovereign interests of nations, and it is up to the offended nations to determine whether a violation of sovereign interests occurred and requires redress. They don't exist for the benefit of individuals. This is so that states can deal with each other on a state level. Individuals are incidental beneficiaries of that at best. So there's no such rights created in all of these different international treaties that Noriega has cited. They just set forth broad general principles governing the conduct of nations toward each other and do not by their terms speak to individual or private rights. Thus, under applicable international law, Noriega lacks standing to challenge violations of these treaties in the absence of a protest by the Panamanian government that the invasion of Panama and subsequent arrest of Noriega violated that country's territorial sovereignty. So he considers this kind of counter-argument. It can perhaps be argued that reliance on the above body of law under the unusual circumstances of this case is a form of legal bootstrapping. Noriega, it can be asserted, is the government of Panama, or at least its de facto head of state, and as such, he is the appropriate person to protest alleged treaty violations, to permit removal of him and his associates from power and reject his complaint because a new and friendly government is installed. He can further urge, turns the doctrine of sovereign standing on its head. This argument is not without force. Yet there are more persuasive answers in response. If you can just get around international law by regime change, taking out the head of state you don't like and installing your own puppet government, and the puppet government says, "Good job, guys." Yeah, that is kind of bootstrapping. It's creating, the outcome that you want through your own wrongdoing. But there are more persuasive answers in response. First, as stated earlier, the United States has consistently refused to recognize the Noriega regime as Panama's legitimate government, a fact which considerably undermines Noriega's position. So that would be the case with Maduro. Maduro can't protest on his own behalf that the U.S. violated the treaty because he's not the legitimate government, according to the U.S. Secondly, Noriega nullified the results of the Panamanian presidential election held shortly before the alleged treaty violations occurred. The suggestion that his removal from power somehow robs the true government of the opportunity to object under the applicable treaties is therefore weak indeed. We got a similar situation here because the last election was, not that long ago, and he just decided he's not going to leave. Finally, there is no provision or suggestion in the treaty cited which would permit the court to ignore the absence of complaint or demand from the present duly elected government of Panama. So this will be a wait and see with Delcy Rodriguez. Is she going to protest? Is she going to stay in government? I mean, there's kind of a lot of big questions about that at this point. But it's kind of at best an open question. So Article 3 of the Geneva Convention doesn't apply. They say it's just impurely domestic, doesn't apply to the military invasion of Panama. And then the Nuremberg Charter, which prescribes war crimes, crimes against peace, and crimes against humanity. So these are Nuremberg tribunal processes. They say doesn't apply. He fails to establish how the Nuremberg Charter or its possible violation, assuming any, has any application to the instant prosecution. Kerr-Frisbee doctrine applies. Defendant has not cited any language in the Nuremberg Charter nor in any of the above treaties which limits the authority of the U.S. to arrest foreign nationals or to assume jurisdiction over their crimes. The reason is apparent. The Nuremberg Charter, as is the case with the other treaties, is addressed to the conduct of war and international aggression. It has no effect on the ability of sovereign states to enforce their own laws and thus has no application to the prosecution of the defendant for alleged narcotics violations. The Nuremberg Charter was about prosecuting war criminals in international court in The Hague. Well, I think in a variety of places, but there was Eichmann in Jerusalem, right? That wasn't Nuremberg, but that was a whole different thing. Maybe we could get into that sometime when the topic of kidnapping people and bringing them to a foreign country for prosecution, maybe an early example of that. But, it didn't happen in America, so it doesn't matter, right? Oh, God, no. I'm kidding. I'm kidding. But that is, unfortunately, just the way things go down sometimes. We all probably have a little bit of a centric perspective on our own countries, our own histories, and things that matter to us and stuff like that. So I am just kidding, guys. So ultimately, the violation of international law, if any, may be addressed by other remedies, does not depend on what amounts, the granting of what amounts to an effective immunity from criminal prosecution to safeguard individuals against police or armed forces misconduct. The court therefore refrains from reaching the merits of defendant's claim under the Nuremberg Charter. And so now we get to the last issue, the supervisory authority. It is really just a catch-all. And we'll go through it, but it's just kind of a fancy way of saying, this is the shocks the conscience kind of standard that I've talked about before. Basically, that getting the court involved in this type of situation would be unseemly. It would be lacking in integrity. It would impair the good opinion of the courts. So having determined that defendant Noriega fails to state a valid defense based on due process and international law principles, this court's inquiry is nonetheless unfinished, as defendant Noriega alternatively bases his motion on the inherent supervisory power of the court. Noriega alleges that by asserting jurisdiction over him, this court would thereby sanction and become party to the government's alleged misconduct in invading Panama and bringing Noriega to trial. This kind of argument is really not unprecedented. An example of kind of where this comes up that jumps out in my mind is in the case of racially restrictive covenants. This used to be a fairly common practice in certain neighborhoods where you could have, kind of like the same way you have an HOA and stuff like that. You would have neighborhood restrictions that would limit people's ability to sell their property to members of certain races. And so what happens if somebody doesn't go along with that? Somebody violates that. Can you take them to court and have it enforced? And so the court in those types of cases ultimately said, no, we're not going to be co-opted into sanctioning this type of, discriminatory behavior that we don't We don't belong involved in that. You know, whatever people have kind of the right to do on their own. Using the power of the court to enforce discrimination was not something that that would be appropriate for it to do. So it's kind of an example of what they're getting at here. That just because maybe you have the rights, if not the right, at least the power to do something, it doesn't necessarily mean that the court is going to be your handmaiden in the process of achieving it. The supervisory power doctrine, while it may serve to vindicate a defendant's rights in an individual case, is designed and invoked primarily to preserve the integrity of the judicial system and to prevent the federal courts from becoming accomplices to government misconduct. Courts have consequently invoked the doctrine to suppress evidence and dismiss indictments in the face of severe or pervasive prosecutorial abuse. Thus, supervisory authority is in essence a judicial vehicle to deter conduct and correct injustices which neither constitutional nor statutory violations, but which the court nonetheless finds repugnant to fairness and justice and is loath to tolerate. Reminds me in many ways of the cumulative error doctrine. The cumulative error doctrine is this idea that there's a whole bunch of errors in a case, but they're all like really small. They're all really minor. They'd all amount to harmless error. So normally speaking, it wouldn't constitute grounds for reversal. But the cumulative effect of the whole thing serves to basically like prejudice the fairness of it. And so even if it doesn't meet the standard harmful error test that normally is going to be applied to get somebody a new trial, cumulative error kind of says, this is a situation where even if there isn't a technical violation, it just looks so bad that the court's not going to sanction it. So this is like sort of the due process-y equivalent to that. Like, okay, there's not really a violation, but it just really stinks. And so as an alternative to the technical, formality of meeting the requirements of a due process violation, you can't do that. But if you can kind of get the court outraged enough, then maybe they'll just use their supervisory power to say, we're not going to allow this prosecution to go forward. As invocation of supervisory power to dismiss an indictment is a harsh remedy, it is reserved only for flagrant or repeated abuses which are outrageous or shock the conscience. Here we get into that language that you have heard from me before. It is certainly not to be applied as a remedy for mere technical illegalities or inadvertent violations, as these powers should not permit the criminal to go free because the constable blundered. Thus, a higher threshold of government misconduct is imposed for invocation of the supervisory power than that required to state a constitutional or statutory violation. So, it might not meet the technical standard of a constitutional or statutory violation, but it's got to actually be like worse. It's got to be worse misconduct. Which maybe is a little bit, I don't know, is that a little bit contradictory? Is that a little challenging? Again, it's not unprecedented. It has been done, so it's not an impossible standard to meet. But ultimately, it's going to be an extremely rare and unusual set of circumstances that meets it. Noriega argues that his arrest and presence before the court was secured as a result of deliberate and indiscriminate atrocities committed by the United States in the course of its invasion of Panama, and that such conduct shocking to the conscience calls for an exercise of the court's inherent supervisory authority, resulting in dismissal of the indictment. In response, the government argues that even pursuant to the court's inherent supervisory authority, Noriega may not seek dismissal of the indictment based on alleged violations of the rights of third parties in this case, the rights of individual Panamanians or of the Panamanian state. So in other words, if other people, like maybe your entire security apparatus, had their rights violated in some way, you're not going to have standing to invoke that under this particular doctrine. This is just kind of an extension of the principles that deal with jurisdiction and the invasion of sovereignty. These are not rights that are there to protect you. This is like state level stuff. This is court level stuff. So just pointing at they did bad things to somebody else probably isn't going to meet that standard. The government's position thus seems to be that a defendant's own constitutional or statutory rights must be violated in order to trigger the exercise of a court's supervisory power. But this stance blurs the critical distinction between the use of supervisory authority on the one hand and the court's rulings based on violations of constitutional and statutory law on the other. You have to have standing for a constitutional violation, but we're not in that framework. So the court is saying, I'm not so sure that I buy that. Like, I'm not so sure that you can't raise the taking out the security apparatus just because it wasn't you personally that suffered that particular harm. If it's egregious conduct that they engaged in for purposes of bringing you to court, then it's something that the court can take into account. Since, as stated earlier, use of supervisory authority presents an independent body of law and does not depend on the existence of a constitutional or statutory violation, the fact that a defendant's own such rights have not been violated is not decisive. A contrary result would indeed render the doctrine meaningless, since dismissal of an indictment or other remedy would thus flow from the required constitutional or statutory violation, and invocation of the supervisory authority would therefore be unnecessary. So he's just making the point that what the state's really doing here is just conflating this into standard errors that we already have. If you have standing to argue a violation of your rights that's egregious, then we already have the case law and the doctrines and so forth to remedy that. We don't have to have this whole independent body of jurisprudence dealing with should the court be implicated in this type of activity at all. Contrary to the suggestion implicit in the government's position, supervisory powers cases are not constitutional cases in disguise. So Painter is a case that they're saying this is different, doesn't apply here. Painter, the Supreme Court held that the supervisory power doctrine could not be used to suppress evidence obtained in violation of a third party's Fourth Amendment rights, because evidence is excluded under the Fourth Amendment only where an unlawful search or seizure violates the defendant's own constitutional rights. That's the standing doctrine. The court refused to allow a different result under the supervisory power doctrine, as that approach would circumvent the careful balance of interests embodied in the Fourth Amendment decisions of this court. You're making an end run around the Fourth Amendment jurisprudence if you're saying, I don't have standing, they violated somebody else's rights, but you should be offended by that and do that anyway. Good example of this might be that whole IgG thing, right? The feds are going into the databases without permission. They are violating the rights potentially of hundreds of thousands of people who are in those databases that did not consent to having their personal, highly detailed genetic information available for government investigation. And FBI is getting in there and doing it anyway, saying we don't really care about whether you consent or not. You got a standing problem if you're not in the database. You're a defendant who is identified through IgG, but you personally aren't in there. You don't have standing to challenge it. That's what we ran into in the Koberger case. That was a situation there. Possible end run around that is the court to say, well, but this is really egregious, and so it's not something that the court should, wipe its hands of, and just, not something I have the power to grant any kind of recourse for. They're not going to do that. This case is making that clear. We're not going to create exceptions to the Fourth Amendment rules that we already have by just putting them under this catch-all of the supervisory power. The court's concern was simply to prevent supervisory powers from being used as an end run around Fourth Amendment law, but its decision explicitly did not limit the traditional scope of the supervisory power in any way, nor render that power superfluous. Since the illegal search at issue in Painter did not rise to the level of pervasive or shocking misconduct imposed under the doctrine of supervisory authority, the court's narrow holding can hardly be construed to render that doctrine meaningless and the judicial system helpless in the face of inhumane conduct shocking to the conscience merely because technical standing requirements are not met. This kind of suggests that maybe there is a little sliver of room for that type of issue. It's pervasive, it's ongoing. They're just completely disregarding the rights of everybody in that database. Is the court going to be helpless forever? I don't know. Maybe there is a tiny little door here that can be cracked. If, for example, we were confronted with a pure law enforcement effort in which government agents deliberately killed and tortured individuals for the sole purpose of discovering a fugitive's whereabouts in order to secure his arrest, the court would face a situation which properly calls for invocation of its supervisory powers. It would also call to mind Justice Brandeis's eloquent dissent in Olmstead versus U.S. This is a great dissent. I've read this before. Decency, security, and liberty alike demand that government officials shall be subjected to the same rules of conduct that are commands to the citizens. In a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously. Our government is the potent, the omnipresent teacher. For good or for ill, it teaches the whole people by its example. Crime is contagious. If the government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. To declare that in the administration of the criminal law, the end justifies the means, to declare that the government may commit crimes in order to secure the conviction of a private criminal, would bring terrible retribution. Against that pernicious doctrine, this court should resolutely set its face. Isn't that powerful? If our betters don't have to follow the same rules that we do, then we don't actually live in a democratic society of equals, do we? Not even close. Not even close. This court may someday have occasion to apply Justice Brandeis's wise words, but this is not that day. For we are confronted not with the above hypothetical, but rather a military war in which innocent lives were unfortunately lost in the pursuit of foreign policy objectives. A little bit of a fine distinction, isn't it? Some technical things here. A military war, Congress hadn't declared war. Does that matter? It seems it doesn't. Would we call what happened in Venezuela war? Was that making war? It was very fast war if it was. Maybe the only war with, I believe there were no U.S. deaths. I'm not sure if there were any U.S. casualties even. That would be quite remarkable. Can't say that's not possible. But, these are kind of fine distinctions. Used military forces to achieve it. Does that make it war? There's other things. The military do their peacekeeping missions, right? We had that back in Sarajevo back in the day. So it's not real crystal clear, but this is a distinction that they're trying to draw. A military war in which innocent lives were unfortunately lost in the pursuit of foreign policy objectives. Although the motives behind the military action are open to speculation, the stated goals of the invasion were to protect American lives, support democracy, preserve the Panama Canal treaties, etc., etc. Because the president ordered Noriega arrested in the course of carrying out the military operations in Panama, the capture of Noriega was incident to the broader conduct of foreign policy. Was there something broader going on down there in Venezuela other than the capture of Maduro? It doesn't seem like there was, does it? It's certainly a foreign policy objective. There's kind of no way to get around that, but really any government action overseas is going to have some kind of foreign policy implication to it. It's going to be related in some way to the foreign policy of the United States. So in this case, they seem willing to kind of excuse it because it wasn't the whole point. But in Venezuela, it kind of seems like maybe that was the whole point. So is that going to be enough of a distinction here to make a difference. I mean, the reasoning is gonna have to be different. If the Southern District of New York is, is gonna follow this roadmap and aim at even reaching the same decisions, you're not gonna be able to justify it on the same grounds, at least not on the facts that we currently know. So they had, they had a report and just some details about like what was going on and what the purpose was. They specifically rejected the arrest of Noriega on drug trafficking charges as a reason for the invasion. So they were totally doing something else, and arresting Noriega was collateral. It was just kind of an aside, an extra bonus. I don't know. The fact that he had declared war against the United States shortly before the invasion only further undermines that premise. Yeah, we don't have that in our situation. We don't have that at all. We certainly had deteriorating relations, but no declaration of war, no overt hostilities, at least not initiated by Venezuela. We'd had all those actions out in the Caribbean towards the boats. But I'm not sure that Venezuela is going to embrace those ships as state vessels necessarily. That foreign policy objectives, rather than just law enforcement goals, are implicated radically changes the court's consideration of the government conduct complained of and consequently its willingness to exercise supervisory power. If you can cast anything in a foreign country as a foreign policy objective, which you kind of can, then I don't know that this is a meaningful analysis. I mean, of course, there's a foreign policy objective to remove the from our perspective, illegitimate president. Regime change. Regime change is necessarily going to happen as a result of these actions. We know that perfectly well. That's a foreign policy objective. It's kind of hard to get around that, just about anything that you do overseas is going to have a foreign policy implication. So is this just saying the court's never going to interfere in those types of decisions? The court is always going to sit back and defer because those are decisions for the executive to make, not for the court to second guess. This is where it kind of starts to get a little trickier, maybe. Where's the line? Is there a line? Is there anything that the executive could do abroad and then, try to transport into the courts for vindication? Is there any line that the court would draw to say, you know what? Just can't do that. I don't know that there is. I don't know if there should be, but that's a difficult question, I think. For the question then posed is whether a court may, under the guise of its supervisory authority, condemn armed conflict as shocking to the conscience. Yeah, just outlaw war. Courts outlaw war. Nothing could possibly go wrong under a system where the courts can just outlaw war. Yeah, that would be just a little bit of a separation of powers issue, wouldn't it? The court, the one branch of government that has no role whatsoever constitutionally in declaring or waging war, ends up having the power to kind of nullify it by undermining its accomplishments. Any such declaration not only runs squarely into the political question doctrine, which precludes courts from resolving issues more properly committed to the political branches, but would indeed constitute unprecedented judicial interference in the conduct of foreign policy. Although the Judiciary Clause of the Constitution does not limit the ability of federal courts to adjudicate issues merely because they present political questions, Judges have nevertheless defined a category of executive and legislative branch actions as beyond the scope of judicial inquiry. Ever since the Supreme Court first claimed the power of judicial review back in Marbury versus Madison, the non-justiciability of political questions is therefore not so much a product of constitutional doctrine, but primarily a recognition of the separation of powers and the system of checks and balances provided for in the Constitution. Judges are not elected, at all in the federal system. They have that lifetime appointment. And part of the reason why is because their role is limited. It's not supposed to be responsive to whatever the political winds are at the moment. And, world events can make these types of things very fickle. One day your friend is no longer your friend. One day your ally is now your enemy. Courts are not the ones that are situated to be making those types of calls. While the exact contours of the political question doctrine are ambiguous and remain a source of some confusion, there's this formulation by Judge Brennan that just has this kind of test for deciding if this is a political question that the court should get itself out of. Prominent on the surface of any case held to involve a political question is found 1, a textually demonstrable constitutional commitment of the issue to a coordinate political department. So war, commanding of the armed forces, those go to the president and to Congress. Nothing about that to the judiciary. It's explicit there in the Constitution. 2, a lack of judicially discoverable and manageable standards for resolving it. We don't litigate war making. We have, these treaties and stuff that set the parameters for how it is to be done. So there's, I guess, some kind of limited authority there in terms of the rules that are available, but we don't litigate war. It's just not something that we have tests for. The impossibility of deciding it without an initial policy determination of a kind clearly for non-judicial discretion. Should we or shouldn't we go into Venezuela to take the president? It's not the kind of thing that you got a legal standard for. It's a policy decision. It's a judgment call. Are we going to or are we not going to? Or the impossibility of a court's taking independent resolution without expressing a lack of respect due coordinate branches of government, or an unusual need for unquestioning adherence to a political decision already made, or the potentiality of embarrassment from multifarious pronouncements by various departments on one question. Getting into a pissing match between the branches of government. This is, again, a different era now. Back in 1990, it's not like everything was like real hunky-dory and perfect and everybody, got along great back then. But I don't know that they would have envisioned just the dysfunction that we have, particularly between, the Congress and the executive 35 years later, 36 years later. Different dynamic at stake. So it seems like a really unusual thing then. Now it's kind of like, well, what else is new? Is it really so shocking that you got 2 bodies of government on different sides of an issue, kind of duking it out over it? I mean, how many issues can we point to where there have been disputes like that? The court, for the most part, because the court's not supposed to be a policymaker, hasn't really, been drawn into that so much. But, pretending that the court is not political, I don't think that's a realistic perspective on the power of the judiciary at this point in time. I think if we're being realistic about what happens in the courts, it's kind of always been the case that certain kinds of decisions, particularly things like constitutional interpretation, have the potential to affect policy really significantly. And the courts do have the power, for example, to strike down legislation as being unconstitutional. Go in and impede Congress, the executive, if he supported the legislation. So being a roadblock and having a beef with another branch of government isn't necessarily like contrary to what the court does at all. So potentiality of embarrassment, it's got to mean something a little bit more than just getting crossways. It's got to be something particularly bad about that. And the use of the embarrassment kind of makes it sound like, standing in judgment on your own politicians. The court shouldn't do that. This is kind of a loyalty above principle almost. I mean, it's how it reads to me. Is kind of what's being implied here. Is don't embarrass your executive, even if he did something wrong. It makes him look bad on the world stage. You gotta stick by him, even if you don't necessarily approve of it. I don't know that that's really what Brennan meant, but it's just kind of the vibe I get from that particular element. So anyway, they spell this out quite a bit, but I'm not gonna read through quite all of that as far as the justiciability. Noriega does not and legally cannot allege that President Bush exceeded his powers as commander-in-chief in ordering the invasion of Panama. Rather, he asks his court to find that the deaths of innocent civilians and destruction of private property is shocking to the conscience and in violation of the laws and norms of humanity. At bottom, then, Noriega's complaint is a challenge to the very morality of war itself. This is a political question in its most paradigmatic and pristine form. It raises the specter of judicial management and control of foreign policy and challenges in a most sweeping fashion the wisdom, propriety, and morality of sending armed forces into combat, a decision which is constitutionally committed to the executive and legislative branches and hence beyond judicial review. If it's war, war is hell. That's not news. War is hell. And certain things are allowed in war that are not allowed in peacetime. Killing your adversaries, your opponents, your armed militants. You're allowed to do that. Don't get to do that in peacetime or just domestically. So it's kind of like it's like the Marquess of Queensberry rules for boxing. Like it's always going to be brutal and violent, and someone's getting punched in the face, and somebody might be walking out of there with CTE or worse. Somebody might not walk out of there at all. But there's kind of some framework around the edges to make it a little bit less brutal, less dangerous, less just ugly to watch, I guess. So if this is war, if going into Venezuela is war, doesn't matter that it might make Maduro and Celia prisoners of war. Doesn't seem to matter. We already went through that part of the opinion. Basically, it's irrelevant. You can be a prisoner of war and also be a criminal defendant. So that's not really a downside that would result from that type of determination. But if it's war, then that also means there's a lot of discretion on the part of the president to decide, when and if to deploy the troops. Set that ball in motion. Questions such as under what circumstances armed conflict is immoral or whether it is always so are not ones for the courts, but must be resolved by the political branches entrusted by the Constitution with the awesome responsibility of committing this country to battle. In this case, the decision to send troops into Panama was made by the president in his capacity as commander-in-chief, and he is on this matter accountable only to his country in his political character and on his own conscience. The court has no authority to pass moral judgment upon that decision under the cloak of its supervisory authority. So just basically some other, working through the standards that Brennan had provided to basically say, if we're going to go in and litigate wartime methods and tactics and things like that, like shocking the conscience. It's all shocking to the conscience. War is hell. War is hell. I mentioned a while back, I was on a kick for a while reading a whole bunch of like military history. Still kind of am, but I got a little bogged down in with the old with the old breed is the one I was thinking of. A War Like No Other. It's about the Peloponnesian War down in Greece, and I'm not really enjoying it that much. But With the Old Breed was a memoir from private in the Marine Corps who went to Peleliu in Okinawa and described what those invasions like, those deployments were like, and just the absolute horror that those soldiers went through, that they endured, the things that they saw. It's just like stuff that turns your stomach. And yeah, that's war, and that's inhumane. It's awful. Our government gets to decide that we're going to do it anyway. It's not for the courts to say you don't get to do that. That's for, we the voters, in terms of who we choose to elect, to influence how those decisions are made. If we don't want that done, elect better people, elect different people with different policies. So this last bit, finally, it is worth noting that even if we assume the court has any authority to declare the invasion of Panama shocking to the conscience, its use of supervisory powers in this context would have no application to the instant prosecution for the reasons stated, since the court would be, in effect, be condemning a military invasion rather than a law enforcement effort. Any remedy would necessarily be directed at the consequences and effects of armed conflict, rather than at the prosecution of defendant Noriega for alleged narcotics violations. The defendant's assumption that judicial condemnation of the invasion must result in dismissal of drug charges pending against him is therefore misplaced. In view of the above findings and observations, it is the order of this court that the several motions presented by defendants relating to this court's jurisdiction, as well as that suggesting dismissal under supervisory authority, be and each is denied, done, and ordered. So that's kind of our roadmap. That's our roadmap of the best precedent we have for a situation like this, and gives us a little bit of the framework of how the Southern District of New York is likely going to have to engage with these issues. It's not a perfect parallel for all kinds of reasons, and so in certain respects, the reasoning is gonna follow, but in other respects, it's not. They're going to have to come up with some type of independent justification. The kind of irony in all of this to me is that at the end of the day, it does kind of seem like there's the greatest distance between this case and the Noriega case is in that supervisory power doctrine, and the facts supporting that. Well, it was a war anyway. There were other things going on. The fact we already had troops in Panama, there had been conflict. We've got the Panama Canal that we have the interests in, that we're there to defend and keep the canal operating and so forth. None of that's present in Venezuela. We don't have any of that. And even just in how they kind of announced this, it was like a law enforcement mission that they did with the help of the military. So, the goal of the prosecution is a lot more front and center in this one than it was with Noriega, at least in terms of how they justified it. So it's kind of different, kind of inviting a little bit of a different rationale for sure. We have to look at, of course, we're 35 years down the road. The entire political situation is different, but there's also just, the realities on the ground as far as the Southern District of New York. Are we really expecting them to be super, super friendly to the presidential administration? Maybe not so much like we would have expected back in 1990 between Florida and Bush. Um, so there might not be the same interest in upholding it and sort of smoothing things out, letting it go forward, coming up with the right justifications and so forth. Maybe they aren't really inclined to do that. But I just find it awfully hard to contemplate that the court would potentially, affect the world order significantly by saying, no, we can't prosecute him. He's got to be released. What happens if he's released? What happens? Does he just go back to Venezuela and reassume office, or what does that even look like? And what's the effect on not just our foreign policy, but what's going on in that country? If the executive, for example, or Congress was making that type of decision, they have so much more access to information than the court does to be able to evaluate, is this a good decision to be making or not? They've got all their intelligence, they've got their diplomatic relations, all that type of stuff. Courts don't have that. They don't get to talk to the spooks over there in the CIA and find out, what's going on the ground in Venezuela, and what's the chatter, and what are people saying about the return of Maduro. How have things, restructured in his absence? Is there room for him even if he went back? Or has he already been crowded out? Have these systems with the cartels and the different organizations involved, and the players, the military and all that, have they already kind of reorganized around new players? Is he going to be fit right back in? It's just I don't know, and the potential implications of that. A U.S. court decision kind of restoring a dictator that we have kind of deposed for them. I just don't see a court really having the confidence in itself and its power, its ability to make a good decision in that regard. I don't know. Maybe they wouldn't consider it their problem. A court can always just kind of get on its high horse. The law is the law. We're here to implement the law, regardless of what the consequences are. And if the consequences are terrible for the people of Venezuela, for example, that's the cost of the law. Oh, I would hate that. I would really hate that. It's one thing for us to bear the consequences of our decisions, but to potentially have, another country, innocent people in another country, suffer because of action, taken by us. Not ideal. Not ideal. It would definitely be better to minimize that. So I have no idea how the decision is going to come out. No idea whatsoever. It's part of what makes this particular case, quite fascinating to me. It's, as we've seen, not completely unprecedented, but there also isn't a real clear real clear path to it. So my goal here today was to just give you a sense of what that roadmap is going to look like, the types of things that are going to come up, the reasoning that's been used in the past. When they said it was just fine, we'll go ahead and justify it. Now, 36 years later, is that going to continue to hold? Are they going to stick with these same principles? Are they going to find a reason to depart? Are they going to point to factual differences between what happened in Venezuela versus what happened in Panama, and use that to justify a different outcome? I really don't know. But this gives us, I think, the best tool that we have to start to evaluate it. And as we get more information, again, if we get information, if this whole trial doesn't end up just being classified and unable for us to really access any of it, then to be able to see how that might fit within this framework that we already have. So guys, with that, I hope you enjoyed this. It's definitely a little bit different for my channel. This is a complicated, very political issue. I don't normally touch politics, and I have tried not to be political about it, because I certainly claim no particular expertise on what's the right thing to do in this situation or not. But I do have the expertise in the court and what the courts do and how they look at these types of questions. And so that's what I've wanted to share with you guys here today. That's regardless of all of the debates out there about should we not have, there is just the bottom line reality of what's going to happen when it ends up in the courtroom. And so this is the framework they're likely to be looking at it through. These are the issues I expect Maduro is going to raise, and gives us a little bit of a hint of how we might anticipate the court's going to be thinking about these questions. So guys, appreciate you joining me. We'll see if we get to see more about this case. I don't know if we will or not, but if nothing else, I hope this was educational little trip through history and through some of these areas of the law that are a little bit more obscure isn't necessarily the right word, but just you don't run across them every day. You don't typically run into separation of powers and justiciability issues in criminal cases. So unusual situations call for unusual jurisprudence. Appreciate all of you. Thank you so much, and I'll see you next time.